Welcome back from the lunch break, picking up on an overview of some of the written discovery vehicles that we covered before the lunch break, and then kind of a transition into some of the evidentiary issues that is putting some of that gold, if you will, into evidence at any kind of trial or hearing. I told you that we would cover deposition pointers in a separate piece of the seminar today, and that's what we're going to tackle right here after the lunch break. Kind of the title, if you will, was Deposition Pointers, Taking, Defending, and Objections that Come Up in a Deposition. On the one hand, taking depositions, I guess if you've done a host of them, doesn't seem all that intimidating because you're not under the scrutiny of a judge, or you're not being analyzed or assessed by a jury while you're asking the questions. So some of the pressure of making sure that everything is as perfectly articulate as you need, and that concise, powerful phrasing that you want to convey when you're conducting, for example, cross-examination, that's absent in most instances from taking a deposition, but that doesn't make the deposition exercise any less important or any less deserving of a tremendous amount of preparation. With respect to taking the deposition, and again, you'll hear me a couple times, I've already done it, kind of go back to some of the items that Jim said when he was first introducing today's topic, the idea of having a plan, assessing, identifying objectives, those sorts of things. This may seem trite, but it can't be overemphasized, which is if you're going to take a deposition of a particular witness, ask yourself some basic questions. Why am I deposing not just anybody, but this witness? What's the goal to be achieved by questioning this particular person and at this particular stage of the case? Don't just kind of go through the motions. It's easy to get caught up in, just the kind of turbulent, just cycle of a case and not stop routinely to assess what is it that we need to establish, what do I need to learn? It's called discovery after all. And is this the person I'm going to learn it from, and how am I going to learn it? All of that is something that you should take into consideration for each and every deposition, because it may dramatically impact the questions you ask, the style of questions you ask, how you approach certain issues. There's really no kind of cut and dry approach that is the appropriate means for each deposition. They all may take on kind of different flavors. So we're going to start with taking a deposition. We'll talk a little later about defending a deposition and some other related issues. It is, in fact, discovery. You are discovering information. So despite probably all of us wanting to maintain total control and being the ones who are doing the lion's share of the talking, that tends to be what we do throughout much of our career, I strongly encourage you to put what your elementary school teacher told you as your listening ears on. Be a spectacularly attuned listener, and you will be a much better deposition taker. Try to put things in a way that will convey to the witness an opportunity to just talk, tell stories, explain. There are instances when you need to be much more surgical and zeroing people in, but for the most part, see it as an opportunity to gather, discover information, and then you can slice it, dice it, assess it at the appropriate other intervals in the case. But until that person starts telling you things, you really don't know everything that they know. So come up with an opportunity where they will start talking to you. I have been much more effective in my career by utilizing a very disarming kind of approach with people including the opposing party and everything else. I think Jim, in a different context earlier today, was talking about, when the client comes in and insists on being a total bulldog and this and that, trying to convey that normally that's a less effective means. And I think that concept applies straight on in the deposition taking context, that most people are so nervous that if you can come up with any opportunity for them to just kind of take a deep breath and answer your questions in a kind of understated, routine way, you're going to be substantially better off. Because don't forget, and we'll talk a little bit more about defending depositions, but they certainly were taught in their deposition preparation session, if they had one, that less is more. Right? The more words you say, then the questioner, Van Horn, will just take your answers and turn them right around and use your words back at you. A long answer begets more questions. Although that's true, everything you can do on the questioning side then to encourage a witness to become comfortable enough that they start discarding the warnings from their counsel about the necessity to be concise, and you can just get them talking, you're substantially better off. Some of it may not ultimately be useful in your case, but boy, if it is, that's a great successful day taking the deposition.
I had a deposition of on a very large case of the principal person on the other side who happened to be someone, a foreign individual, so he had to travel to the United States, and he had obviously been told that I was going to, jump all over his head and be a bad guy all day long. And I did exactly what you just said, Chuck, which was to be friendly with him in the sense of trying to get him to talk. And he talked and talked and talked and talked. And it was a wonderful day. At the end of 7 hours, the maximum time we could take his deposition, he remarked to me, he says, wow, you weren't as bad as they told me at all. He remarked to me off the record, but while we were still in the room, that he wasn't expecting me to be that friendly to him, which of course was interesting because obviously that let me know what his attorneys had told him about me, but it also went to your point, which is I got much more effective testimony, and he volunteered all kinds of things and gave me everything I was looking for because I got him talking as opposed to just asking, leading questions, yes, no, that sort of thing.
So when you're asking your questions, in addition to being disarming and kind of gaining information, a couple other things to kind of think about. So make sure you have your goals in mind, right? What do I intend to learn from this witness? And that could be also something that I'll kind of think about in the contrarian way, meaning it could be your goal is to establish the absence of something, to disprove some concept. That the claimant really doesn't have any evidence to support such and such allegation. Could be one of your goals. And know what you're going to use the deposition for. That is, have you already planned that this is going to be a case where you're going to file a summary judgment motion? Is it a case where that's just not appropriate, but someday the case might get tried and this witness is likely going to testify? Then you need to be sure that your questions also could be used, if necessary, for impeachment purposes. And so those are much different things, and that will require you to, again, put your listening ears on to make sure that the testimony you're able to elicit is satisfactory for all of the purposes for which you've set up the deposition. That may not make a ton of sense as I just said it, so let me give you the perfect example. Again, using a war story, I was going to try a case. Another lawyer in our firm had done a lot of the litigation. He did not have much trial experience, but a very effective litigator. That is, he was very good at depositions, great brief writer, and so forth. I was crafting a bunch of cross-examination for use at trial, and I was using the deposition as kind of a go-by for certain mileposts in the case and making my little notes as to how I would use this for impeachment if the witness contradicted what I expected him to say. Problem I had was that the deposition was so clunky and so clumsy the way the back and forth went that the testimony was absolutely useless for purposes of impeachment. And I'll go a little bit more detail. So in the summary judgment context, and we've all been guilty of this in a deposition, I start asking a question. The witness starts answering. Inevitably, neither of us are speaking in complete sentences because that's frankly the way most of us speak, is just using phrases and we keep talking over each other. But in that rat-a-tat-tat back and forth, I elicit from the witness that the contract was signed on such and such date. For purposes of summary judgment, that's a totally appropriate citation to use, that sworn testimony says that this contract was signed on X date. Perfectly fine. You give the line and page, and the fact that there was really no Q and no direct A back and forth, it might have taken almost the better part of a page to get that fact elicited, has no impact on its validity for use at summary judgment. You can just say, Judge, I've established the contract was signed on that day. Now, fast forward to trial. And for some reason, if that testimony, now again, I'm using an example that's incredibly artificial, but bear with me, that witness gives an alternative answer. So I want to whip out that deposition and say, you remember you sat in office and you had a court reporter and you were under oath, and all of the things to make an impeachment a dramatic, impactful event at the trial. So the jury's like, wow, something's about to happen because Van Horn is getting agitated and he's getting dramatic. Something neat is I got to pay attention to this. And then I'll say, see, I asked you question. Well, and see, A was okay, and then I said, and it takes 6 and 7 back and forth, and then ultimately it's like May of 2011. I've lost everything. There's really no Q and there's really no A. The aha moment is totally absent. So again, knowing what the deposition's purpose is something that you need to keep an eye on. You're cruising through that deposition of all the things that you're trying to remember. You're trying to make sure you've established, for example, again, my bad illustration of the contract signing date. But you need to be aware that the back and forth that got you there was really clunky. That's okay. Just take a pause, and then you can just restate the question in a way that's very simple, right? Mr. Witness, thanks for that. Just to make sure you and I are on the same page. The contract between Acme on the one hand and ABC on the other hand was signed in March of 2011. Yes. You've really gotten it twice, but now I have it in a way that if I need it at trial, I have it in 11 or 15 or however many words it was, and it's not the better part of kind of that back and forth that's just totally ineffective. And that skill set only comes from having tried cases when you've searched and scrubbed through a deposition looking for something to use for impeachment purposes, and it's in a form that's unusable. So the experience I was identifying was reading this deposition and realizing that this lawyer who had not tried a jury trial by himself before probably didn't appreciate that impact, that missing piece from the deposition. He did a darn good job getting from this witness the information needed, but it wasn't in a form that was usable at trial. So just be aware of that impact. There's another example that I put in the materials that has kind of another display of that same concept. One other variable to consider when you're utilizing a deposition of a witness is what documents you're going to introduce and when. A well-advised client or witness will be told, don't answer anything about a document unless it's put in front of you, and then use the document as your go-by. So in a lot of instances, I'll hold all my documents and I'll just talk. And you remember you did this, and then this happened, and then some folks ended up doing an agreement, and then tell me about how life went after that, and try to get as much out of the witness without handing them the document as possible. That idea doesn't apply to every case. That's not an always kind of proposition, but it is a way to eliminate the witness not really testifying for himself or herself and just being a reader of the document. We've all experienced that, where every question the witness immediately dives into some contract or some exhibit and really just starts reading from it, and you've kind of lost your ultimate goal, which is to elicit from this witness his or her take on things more generally. And again, that doesn't always work. There are times when you need to lay the documents out ahead of time and then utilize those for a lot of your questioning. But don't lose sight of the fact that there may be opportunities to gather a lot of information and then later introduce the documents and work a witness through certain other facets of things. In addition to documents, think about the use of pleadings in a case. This is particularly true. I'll use as an example, earlier Jim was talking about an instance where a party has pled something very legally particular like punitive damages. Fraud is something that comes to mind. You'll set up a deposition, and that's a time where I will typically put the pleading in front of someone and use that as a guide and say, you guys have filed this, right? And then just say, all right, let's read paragraph such and such together. And it would be an allegation that your conduct was so outrageous that punitive damages are, triggered or are necessary, or fraud, you misrepresented, you're a liar, those kind of things. And then just slowly work through with them. All right, tell me every example you can give me of what we lied about, what we misrepresented. And you're setting yourself up to head straight toward some kind of summary judgment motion in the best day when they really struggle to articulate certain things. And that's a really good use of handing a witness a document ahead of time, working through with them. I have had great success working through pleadings. I'll give you one other example, and there's other uses for pleadings for sure, even in the deposition context, is remember the sloppy objections we were talking about earlier in interrogatories? An interrogatory is a sworn statement, right? And we all know that in the worst form, it's just riddled with a bunch of legal gobbledygook that the lawyer slipped in there with very little substance. But to Jim's point earlier, when he was talking about things, it'll say, identify all facts that support such and such, and he was saying in Minnesota, for example, that may be the jumping off point that leads you to amend and adding a claim for punitive damages or something. In a deposition, I can sit there with the witness and literally ask him or her the question. It says identify all facts. That was back, a month or two ago, so you may have more now, but all right, let's talk about it. And when they realize just how skinny and skimpy that answer is, it really will put them in kind of an awkward defensive position to say, all right, well, you're here, you're supposed to tell me. And a lot of times they're totally ill-prepared to articulate themselves as to why they think that claim should or should not be supported. That's a very good use of pleadings or discovery, especially when you're anticipating that deposition testimony being utilized for purposes of some kind of dispositive motion. Some other things with documents is we are all guilty of kind of almost jumping in too fast, handing someone a document, and sometimes you just want to keep going. So you'll say, I'm handing you this, it's dated this, it's such and such, it's such and such. Don't lose sight every once in a while of just asking the witness, do you have any idea what this is? And it may be shocking when someone who's the CFO says, I don't know what this is. All of a sudden you have the head of their entire finance area can't identify what some Excel spreadsheet is. That may be pretty helpful when it comes time to poking holes in, for instance, a loss profit analysis or things like that, right? When someone just right off the bat says, I have no idea what this is, I've never seen it before. Again, in the right circumstance, resist the temptation to suddenly educate them about it. Well, everyone else in the case has told us that this document represents such and such. And then a smart CFO witness is all of a sudden cued in, and then they're off to the races. And you've almost rehabilitated your opposing party's witness and kind of reminded them kind of why they're there and what the case is about. There's different schools of thought on all of the background questions in a deposition where, and we've all experienced people probably really go to the well too much on this, but spend 20, 30, 40, an hour going through where did you go to high school, what did you do next, what's the first job you had after college. And you're sitting there thinking, my witness is 55 years old. That is a lot of jobs. Are you sure we have the time for this? I tend to jump around with my background. I tend to not want to spend a ton of time on it on the front side, particularly because I feel like it just starts to get to be somewhat of a waste. That said, Jim was talking about this one particular witness who had all the earmarks of being fairly hostile. Sometimes the background is a good way, especially if it's not laborious, to kind of get everyone to calm down and get the witness used to the back and forth, the ping pong action, if you will, of the Q&A itself, because it's incredibly artificial. I tell all witnesses that the deposition is the least effective way for me to get information because you can't start talking until I finish, and I'm not supposed to start talking until you finish, and no one really speaks that way in normal communication, so just take your time and we'll get through it. So sometimes the background is a way to warm your witness up a little bit and just get them used to who you are, that you're not, the devil, as they've been warned ahead of time, and some other things. But I would really encourage you to think long and hard about just how much of the background you want to go through. Saying that, there are some uses of background before you get into the substance of the case where the witness's attention will be heightened that you represent the party that's adverse to them, right? So they're going to take everything with a grain of salt and be uber skeptical of everything you say. So if you're going through some background and it looks like this person's had, for example, a series of positions in the real estate industry, while you're still running through their background, that's probably a good time to get them to concede they're pretty well versed on real estate principles. They've been doing this a long time, not quasi-expert, but you get the gist. Whereas if you're doing it once that person's head of retail operations at the company, you're like, well, they have you doing that because you are so good at this and you've been doing it so long. You may start getting a more guarded answer where they're going to think, ooh, he's saying that to trick me. I need to be really sensitive to what he asked me to agree to now that we're talking on issues very close to the dispute at hand. So just be sensitive about background because it can get to be kind of a drag, and to the extent that you're tuned out, everyone else in the room is tuned out as well.
On background for me, I agree with you. You can do, if you're going to ask a 55-year-old person, okay, from the time you left high school till now, why don't you document every job you've ever had? That's probably going to be pretty unuseful. On the other hand, I do want to get a sense of how is this person going to portray to a jury? I mean, are they a military veteran? I want to know that for my jury panel. Are they, do they hold professional designations? Do they have a criminal background? I'm going to ask some basic questions. I'm also going to see how they're going to react to some of those questions. But, I tell this story. I have an expert witness I use in construction cases who was a professional hockey player. He also played on the U.S. Olympic team, hockey team. Okay, the other attorney never asked that at his deposition. He didn't know any of that. I got to trial. We're in front of a jury in Minnesota where hockey people are legendary. And I said, now, before you before you became a contractor and started your own business, what did you do professionally before that? Well, I played for the Minnesota North Stars. Oh, so you're a professional hockey player. Tell us about that. Well, and the jury lit up. Like, wow, this guy is a professional hockey player. The other attorney had no idea. And his client looked at him like, you didn't know that? You know, how did you not know that? Well, he never asked even some basic background questions, never looked him up. It's not on his resume, it's not on his CV, it's not on his website, but lo and behold, he played on the U.S. Olympic team, and that's not something you want to discover at trial.
No question.
Right, I mean, this guy is a hockey hero. So
on the background, I'm going to change tacks a little bit, and then I'm going to get into some to the defending and objection issues as well. Again, going back to the goal, again, learning, is it to disprove? Is it for preparing for trial? There's a host of different objectives. In the right circumstance, the use of background, for example, can be almost the opposite. Sometimes it can be very disarming to a witness who otherwise appears to be a little too comfortable and confident in their position and confident that they're in charge of you, that sort of thing. We've all experienced that witness, the hubris, if you will. If you have their LinkedIn profile or you've done some other kind of snooping around about this witness, to be able to tell the witness things that you know about them. Rather than say, what did you do next or what did you do before you became a general contractor? Because all of a sudden they may start thinking, what else does Van Horn know about me? And that can be just a very disarming way, again, to regain control. Last thing before I talk about defending depositions is I told you about being a good listener, being very conscious of witnesses who are not answering your question. They are really good at it. I've read some depositions I've taken and I thought, doggone it, he or she didn't answer that question. And so really slowing your own brain down to listen to their answer before you start hustling through your outline, moving on to the next item, the next document, the next question, you're turning the page to the next portion of your outline. Make sure you got an answer to your question. Doesn't have to be an answer that you like, but make sure that they didn't sidestep your question, because then you talk about useless. You're going to advance all the way to trial, and you really have no way of reining that witness in or have any control over what that witness would say on a particular issue. For defending a deposition, I've talked mostly about taking. I frankly believe that defending a deposition is much more work than taking. Taking, if I ask a crummy question, I can just ask it again. But if my witness is ill-prepared or if I'm not on the ball enough to identify either an objectionable question or some other problem, it's too late. I can't say, hey, can you ask that again because I forgot to object the first time. Defending a deposition, you need to be prepared for making sure that the questions are not duplicative, that they're not somehow onerous, that they're not compound. You remember that this was already covered earlier. They're not misstating testimony. Those are all valid grounds, and I would encourage you to hammer out ahead of time what rules you're going to use with the opposing lawyer for the treatment of objections. Are they going to be cured on the spot? Are they all reserved until the first use of the deposition? I think the standard tends to be objections as to the form of the question or the responsiveness of the answer are made at the time. All other objections are reserved until the first use, which typically is summary judgment. It could be trial. But that may not be what you want. But make sure you understand what that means. That is what you're agreeing to ahead of time. And be super sensitive to how you're objecting to form, that you are not bleeding into any problems where you're being accused of coaching a witness. I've included in the written materials a couple citations from some federal cases where lawyers were taken to the woodshed for these extensive speaking objections, and they end up getting sanctioned for it because they're interfering with a witness's capacity to testify competently and comprehensively and interfering with the lawyer's ability to ask an repeated deposition colloquy. The defending depositions, like I said, I don't think it's easy. I want to see all the documents before the witness starts testifying about them. So I tend to just kind of put my hand up and tell everyone to stop for a second so I can make sure that what they're being asked about is in fact something that we're generally familiar with, so that things, again, don't get out of control where the witness is agreeing that such and such's exhibit is in fact the customer agreement when it is riddled with either extra pages or it's missing pages, it's the wrong version, and it just becomes exceptionally clumsy to try and fix and dig out from that hole. And a slick lawyer on the other side will try and capitalize on things that are otherwise innocent mistakes. And if you're not, if you're a little asleep at the switch, you won't be able to kind of correct those as they're happening. In preparing your client for a deposition, I have seen it done by a host of different lawyers in my career, and I've kind of modified my style over time. I really believe that this is an area where collectively we tend to not do a good job. Clients are very sensitive about the amount of time that they spend away from work or doing other things, and they're going to take a day off to be deposed and a host of other things, but not appreciating how much prep time is needed is, I think, a flaw on the client's side, but also on our side, in letting the client appreciate the advantage and the bonus gained from an adequate preparation session. And that includes more than just the rules of the road. Jim alluded to the fact that it was clear this one client he was mentioning earlier had been kind of, focused on being concise, and that Jim was evil and to, only speak when spoken to kind of things. But there's more to it than that. A good questioning lawyer can come at things from a variety of different angles and may get a hit on a certain line of questioning and end up kind of striking gold, if you will. So one of the big things in my prep sessions is to make sure that the witness generally understands kind of the concept behind the case. Now I'm speaking specifically to a client prep where privilege applies and those sorts of things. So if your client doesn't understand what a fraud claim means, just generally, this is how fraud works. We as the claimant have to show that there was a false statement, that it was made known to be false, that with the intent to rely, those types of conditions. A good questioning lawyer can trip your witness up on what he or she believes are the facts that support fraud, because they have no idea that a certain phrase matters or doesn't matter, or that one of the things we're fighting over in the case is this phrase in the contract. And our position in the case is that this phrase means blank. So then in the deposition, when that phrase is just used generically, let's pretend I'm the questioning lawyer. I've not shown them the contract, so they've not seen that phrase right on page 2 to alert their memory to it. All of a sudden, I just use that phrase very innocuously based on all their other experiences. It may be that I can kind of start leading them down a path that's contrary to the theme of the opposing party's case more generally. So I think that's probably the big part of prep that is not emphasized, is just to make sure the witness appreciates kind of where they fit into the larger scheme. They may think, oh, I'm just the rank and file person out of this department. I'm really here to answer questions about some accounting gestures. And that may largely be true, but don't be surprised if while they're there, kind of these other vague questions that are theme-oriented come up. And if they're ill-prepared, it's pretty difficult to start rolling that backwards. Because what are you going to do? Try and educate them at a break on what your case is about and how they need to change, their prior answers and all this? That is just a big problem that is so easy to avoid on the front side. Those are some of the things that jump out to me in terms of depositions, the use of them. So we've now taken a lot of the documents that we gathered through written discovery or the information we gathered from interrogatories. Requests for admissions. I was using the example of handing a witness a question and saying, quizzing a witness about an interrogatory response. You hand a witness a request for admission where you say, please admit that this is true. And it says denied. And you're like, well, Jane, is that true? Well, yeah. You're like, then why did you guys deny it? I don't know. Have you ever seen this before? No. I mean, you can see where those things, again, very innocuous, but can be hugely effective. So now you're starting to see where some of the very early planning Jim was talking about, leading us into analyzing what the damage is, what's at stake in the case, and then all of the written discovery kind of culminating in the deposition forum where we're using a lot of this information and putting it kind of into action. We'll go through a couple more pieces of some pretrial litigation before we wrap up today, but that's probably really a good point to jump off in terms of some rules, tips of the trade for taking and defending good depositions.